Now I'd like to invite Mr. Chavis to address this convocation.
Thank you, Treasurer. If I wobble, bear with me.
Again.
Wobble,
Did you say waffle?
No, I just said wobble. If you and I were thinking the same way,
I never known you to waffle on me. Wobble on, Mr. Chavis.
Thank you, Treasurer. It's been noted already this morning how fortunate we are in Canada to live in one of the most diverse, tolerant, non-discriminatory societies in the world. While certainly not perfect, Canada is a beacon around the world for respecting and protecting human rights. Our recent leading role in striking down laws that discriminate on the basis of sexual orientation has been lauded and followed in many countries. A fact I think most of us in this room are very rightly proud of. The Law Society has a great deal to be proud of in this area. Our strong commitment to equity, equality, and diversity in the profession, our programs to prevent discrimination and to assist persons from historically disadvantaged groups are all part of who we are as an organization and of what we stand for as a profession. It's no accident, as Mr. Mackenzie pointed out earlier, that we have a rule of professional conduct that prohibits discrimination. And in keeping, though, with the view of Mr. Mackenzie that we have to maintain an open mind, I too have been carefully reading everything and will continue to read and review everything before I vote on this. But I do have a view on this. I have formed a view, a tentative view, a strongly held tentative view on this, which I intend to express. Just last month, at the request of the Human Rights Monitoring Group, Convocation approved the issuance of letters and a public statement regarding the anti-gay laws passed in Uganda, specifically expressing concern over the persecution of gay lawyers or of other lawyers or advocates who advocate on behalf of homosexuals or wish to challenge those horrible laws. A no-brainer. The motion passed with the usual overwhelming support of this body. But do we not apply the same standards and commitment to human rights at home? Because, in my view today, I would say make no mistake, approving Trinity Western's application would be a discriminatory act by our Law Society. By approving or crediting this law school, we approve and accredit a path to licensing that is open to some and not to others. We grant a special status, as Mr. Mercer said, an entitlement to a school that discriminates against those who will not, cannot sign the community covenant because of their sexual orientation. We then create a situation where fewer places for admission into our entitlement, our licensing process, through attending an accredited Canadian law school, are available to some and not to others. Not to those LGBTQ and others who find it offensive, but to them in particular. Trinity Western University, as Mr. McDowell pointed out, the Supreme Court said it's not for everybody. That if we accredit them, then our licensing process and the routes to entitlement under our licensing process aren't for everybody either. That's marginalization, that's discrimination, and that is harm. This is not to say that followers of Trinity Western and their covenant do not have rights to, but when they take these beliefs to us and ask us to accredit a discriminatory path, their religious freedom is attenuated, to use the words of the Supreme Court in Wapcott and NS, because it has a discriminatory impact. So my view today is that I do not see this as a clash of competing equal rights. No one is preventing Trinity Western from operating their university or even opening a law school and maintaining their beliefs and practices. Trinity Western can discriminate all it wants on its private campus, but when it asks us to accept their school as one that gets a pass into our licensing process, we have to apply our own values. We cannot ignore the discriminatory nature of the institution. It seems to me today that we must apply the law and say no to the value that does not respect other values. And that to me is why, for example, the eloquence of Mario Cuomo, quoted by my good friend Mr. McDowell, I say doesn't apply here. We're dealing with a discriminatory practice, maybe under the guise of freedom of religion, but it causes harm, it causes discrimination. Trinity Western can, one could say, hide its discrimination behind the exemptions in the British Columbia Human Rights Code, but we can't. We do not discriminate, and we cannot turn a blind eye to Trinity Western's discrimination when they seek to make it part of our path to licensing. So in my view, today, I see the decision as an easy one and supported by everything we claim to be about. In response to the argument that saying no will somehow discriminate against the graduates of Trinity Western, or that we're refusing to admit people to our society who hold those views, that is just not so. We aren't barring their graduates or people who ascribe to the covenant from membership in our profession. They just have to take a different route. And students who choose to attend Trinity Western will know that one of the consequences of that is that, like the students who go to the University of Leicester in England or another unaccredited university, that there's a different path. So again, in response to my friend Mr. McDowell, I say we aren't barring anybody. We are making our own decision about our the entitlement to licensing under our procedures. And it kind of astonishes me how lawyers can twist themselves in knots over this. I read with alarm a statement in the materials by someone I respect who suggested that there was no real public interest basis to refuse this application. Since when is the prevention of discrimination not in the public interest? What is the public interest, if not, among other things, the eradication of discrimination? Unfortunately, the Federation of Law Societies didn't or couldn't consider the public interest. And that is unfortunate, because some have raised the specter that we'll have different provinces accept. Some may accept it and some may not. And that could be a bad thing. It's contrary to what the existence of the Federation is all about. But uniformity or conformity is not a justification for discrimination. Sadly, the Federation may have brought that problem on itself by not looking at the broader issue. But whether or not they could have stopped this, we at least have the obligation to consider the matter broadly, reflecting our fundamental values rooted in the Law Society Act, the Canadian Charter of Rights and Freedoms, and the Ontario Human Rights Code. We have debated in another context recently, I still have the scars to bear it, the issue of whether access to the profession should be in some other ways unequal, or there should be different paths. But to approve this path is to clearly create unequal and discriminatory access to the profession. As to the Trinity Western decision by the Supreme Court of Canada, some people I know are concerned about it. We've got opinions on it. Let me be blunt. We can make our decision. They can tell us if we're wrong. I dare say they won't. I have read and reread the Supreme Court of Canada's decision, and while not decided so long ago, it smacks of another era, as indeed it was, as we have, as people have commented, moved so quickly in eradicating discrimination on the basis of sexual orientation. One line in that judgment illustrates my point. The weak assertion, and it is weak, that the covenant would probably prevent homosexual students and faculty from applying. Now, it may have been weak in part because the issue framed before the Supreme Court there wasn't about entry into the school, it was about whether they produced bigoted teachers. That's not the issue here. And perhaps it was also weak in part because it didn't reflect the same degree of recognition that now exists, that documents like a covenant that discriminates on the basis of sexual orientation are so clearly discriminatory. In short, I believe the court would not be so equivocal today and would recognize the different framework and context, legal and social, in which we must make our decision. And I believe, and I think the opinions support this, that it will respect our decision and defer to it, as their own law suggests. Finally, let me say this, perhaps as a reminder, what to me, at least today, seems obvious. We wouldn't be wrong to say no. Indeed, I dare say we wouldn't be having this debate if Trinity Western excluded blacks, or persons of, say, Chinese descent, as the Association of Chinese Canadian Lawyers points out in their submission. This is just the same. Based on the submissions received, it looks like most of the profession has no difficulty seeing this as well. My view today is that we must see it that way too. My view today, at least, is that it will be our shame if we don't. Thank you.
I'm going to go to the phone right now to ask people who are on the phone if they would like to be added to the speakers
The
list.
conference is no longer in lecture mode.
Those who are on the phone, is there anyone that wishes to be added to the speakers list at this time?
Yes, I'd like to be added to the speakers list, Mr. Treasurer. It's Virginia McLean.
Thank you, Ms. McLean. Anyone else?
Not yet.
I'm sorry?
Not yet.
Okay, thank you. That was Mr. Wright?
Don't go there, just stop.
We'll put the phone back on.
The conference is in lecture
And
mode.
I'll now ask Ms. Hare to address convocation. Ms. Hare?
Thank you, Mr. Speaker. Ani Nangosa Gashe, Division of Cost. My name is Susan Hare, that means my name is Susan Hare. I'm from the Ojibwe tribe. I'm co-chair of the Equity and Aboriginal Issues Committee here at the Law Society. I understand you've traveled from far away, so we welcome you to the traditional lands of the Mississauga tribe. The combination of religious schools, disadvantaged groups, and laws upholding the same has led to disaster in the past. I bring to you, I guess, a cautionary tale today, and I bring to you the obvious. I speak today about the Aboriginal children's experience with religious schools in Canada, about the laws that upheld them and the religious institutions that cause great harm. These religious institutions, religious individuals, and the newcomer laws imposed with respect to the same used and were used by the faith-based churches who were given the exclusive authority to teach Aboriginal children. Legal agreements were signed between the government and the churches. They were all legal. Laws were passed to punish the parents if they tried to interfere with their children being sent to these religious schools. And I think there is something we can learn from this, or at least something to provide us with caution and open eyes. During that period, Aboriginal spirituality or religion was suppressed and outlawed in Canada. And today, are we talking about fundamental rights regarding sexual orientation being suppressed as well? Indian residential schools were operated by the major Christian churches in Canada and the sub-branches thereof of those churches. Aboriginal beliefs were suppressed and outlawed while strict enforcement of the beliefs of the major Christian churches were implemented under law and by law. I know of what I speak. My family went to Indian residential schools, and I, along with others, including Ms. Backhouse, who's not here today, adjudicated some of the worst cases of institutionalized abuse of Aboriginal children within those Christian institutions. Granted, most students we speak of at TWU are adults, but I would think that some are still under 18 and still children as well. The second point is that the beliefs that came with the Christians, largely from the papal bulls dating back to the 15th century, were that people of color, colonized, people in the colonized world were not considered human. They were considered savages, they were considered like animals. So mistreatment was almost preordained. And while the Bible said, to love thy neighbor as thyself, Aboriginals and others were excluded from that. And it was only the Christian neighbors who fell into that Christian precept. Aboriginal people and Aboriginal children in those schools were made to feel different. The feeling of difference, the imposition on people that you're different from us is very harmful. And there is an inherent message of non-equality I see in the TWU situation. It has the potential to again send this different message to those whose sexual orientation is different than the people who have the beliefs and who run the school. Two of the laws of the Ojibwe are respect and love. Does TWU respect its non-heterosexual students by denying them their most fundamental personal and fundamental choices as adults? I haven't seen a good answer to that yet. The Supreme Court of Canada has said neither freedom of religion nor the guarantee against discrimination based on sexual orientation is absolute. The Supreme Court said there has to be a balance. When evidence of this discrimination comes far too late, the no evidence stance is not palatable, in my view. We must make our decision and we must abide by two principles, in my view, the cause of justice and the rule of law. In finding that balance. The contradiction of values that is inherent in the covenant imposed by TWU on its students. I don't know how that can be balanced. Perhaps it can't. I find I will continue to listen, as I have this morning, continue to read, but I am deeply troubled by the imposition of differences upon other Canadians. And at the end of all of our discussions, I know we will come to a good decision. Thank you, Mr. Treasurer.
Thank you, Ms. Hare. Next on the list. Yeah. Just give me a moment. Next on the list is Mr. Ruby.
Point of order, Chairman.
Yes, Mr. Silverstein.
I must question whether Mr. Ruby should be allowed to participate in this discussion. We were told this morning a number of times we have to keep an open mind. Mr. Ruby's been out in the media quite a bit promoting the opposition to the TW application, and he's been in the media recently about raising funds. So I have to question whether he can provide the open mind that is necessary and commensurate for this debate.
I'm sure that your concern is shared by others as well, but in my recommendations to Convocation and indeed the advice that we received this morning, each bencher has to examine his or her own conscience and come to the conclusion as to whether he or she can have an open mind. Mr. Ruby has been on the record taking a particular position and indeed has confirmed that he's representing a client who will be challenging the decision of the British Columbia government. However, Mr. Ruby does no longer have the right to vote in Convocation on this matter. And therefore, based on that consideration, I don't think that it would be appropriate to not permit Mr. Ruby to express his view in acknowledging, I think, that he has taken a position in the past and will continue to do so without. Mr. McDowell?
Treasurer, I just think it would be very dangerous to allow the fact that someone has taken a position as an advocate to preclude them from making submissions before Convocation. We have to separate those rules out also.
Yes, and I agree.
I agree too.
Thank you, Mr. Strasburg. So Mr. Ruby, please.
Let me confirm what has been alluded to. There will be a challenge to the constitutionality of the decision of the government of British Columbia in consenting to the issuance of law degrees. That decision is one that will go ahead and be challenged in the near future. I am one of half dozen volunteer counsel in that case, and I will help present the case and shape it. But the issue today is not that issue. The issue today is that it is in the public interest for this law society to recognize a degree from Trinity Western. I'm not suing Trinity Western. That different question is a crucial one. And it turns upon their requirement that any student adhere to the covenant, the community covenant they've established, which reflects their narrow biblical view of what is required to be a Christian. In my submission to you, it is wrong to equate being gay with being a moral failure in the eyes of right-thinking Christians. It is hateful, it is destructive, it is bigotry, and I trust that we will reject it. But views, no matter how hateful, that are religious or conscientious in nature, are to some extent protected in this country. And we need that protection. We have a history of suppression of religious and racial groups, which has cost us dearly over the centuries. We should be alive to the need to protect religious minorities. The question then is, what is the scope of freedom of religion? What are we protecting under that rubric? How broad does the protection go? Where does it extend? Is It's interesting to look at the techniques developed, as our colleague knows, in human rights law. Techniques that are consistent with those used under constitutional law for examining these claims to religious freedom. One, they ask, is what's going on in a context that is private or a context that's open to the public? Here, we are very near the totally public area. This is not a school for kindergarten children in the religion itself, which is much closer to the private. This is the preparation and the gatekeeping function for entrance to profession and becoming a judge. Very public. A second one, is this a religious activity akin to prayer for those religions that adopt prayer? Or is it a commercial activity? Are people charged money for it? Is it the kind of institutional activity that the rest of the culture charges money for and conducts in public? Again, this is a law school, not a voluntary Sunday school teaching. These issues culminated in 2001 in a challenge to Trinity Western University and the Supreme Court of Canada. Has anything changed? Well, the first thing that's changed is that the litigants in that case made one claim and one claim only. They said anybody who graduates from this particular Christian university, Trinity Western University, is, by reason of their training and exposure to these ideas, unfit to teach in any capacity in British Columbia. It was a claim about future inability. And it is not surprising that the Supreme Court of Canada responded by saying, that's the only claim you make, and you've got no evidence that's so. And I say that because it seems obvious to us now that some people exposed to this kind of hatred and denigration of gay and lesbian people will be touched by it and unable to teach properly. But many more will not. And that's true of people in every university and every walk of life. Some of us will, some of us won't. So there really wasn't and could not, in my suggestion, be any evidence that future teaching would be tainted. But there have been changes since 2001. Some of the speakers have reverted to it. Let me focus on one change. In 2001, people were alive to the problem that almost anything can be made subject to a claim to freedom of religion. I believe, as a Muslim extremist, that women should not be taught neither reading, nor writing, nor law. And so I'm setting up schools that don't allow any of that. There has to be an answer, because that's not part of freedom of religion. So we start by saying, is this connected to religion? Yes, it clearly is in that example. Second, we say, is it subjectively believed by the adherents? Is it a genuine belief that's religious in nature? Yes, it is. They genuinely believe this is the way God wanted the world to be ordered. So the court developed a test post-2001 as to the objective nature of the protection we're going to grant, how far we're going to grant it. And I'm going to bore you to death by reading you pieces of a case. In 2009, a Hutterite case came up in Alberta, went to the Supreme Court of Canada. And the Hutterites said, quite reasonably, we believe liberally in the second commandment, which says, no graven image shall be permitted. And so they wouldn't allow themselves to be photographed for a driver's license. It was a direct contradiction of a commandment of God and fundamental to their beliefs. It was central. That conflict led to the development of some principles which I think are helpful, and I'm going to try and read you a little excerpt from that case. Anybody wants the citation? It's from 2009, 2 Supreme Court reports 567. The court said, as stated in Anselm, by Justus Jacobucci, an earlier case, religious freedom revolves around the notion of personal choice and individual autonomy and freedom. The question is whether the limit leaves the adherent with a meaningful choice to follow his or her religious beliefs and practices. Not every infringement, not every rule that would stop a religion from doing what it thinks is required in the eyes of God or the deity. It's got a very high standard. Does it leave the adherent with a meaningful choice to follow his or her religious beliefs and practices? And I say that if Trinity Western can only run a law school that teaches a Christian perspective on law, but cannot exclude gays and lesbians by reason of religious understanding of what they think the Bible means, they are still left with a completely intact freedom of religion as we understand it. I go on. There is, the court said, no magic barometer to measure the seriousness of a particular limit on a religious practice. Some aspects of a religion, like prayers and the basic sacraments, may be so sacred that any significant limit verges on forced apostasy. Other practices may be optional or a matter of personal choice. Between these two extremes lies a vast array of beliefs and practices more important to some adherents than to others. And I simply say, if they can run their own law school but can't discriminate, they've got everything they're entitled to under this understanding of freedom of religion, which is new. The court went on. This is not a case like Edwards' books or Multani, where the incidental and unintended effect of the law is to deprive the adherent of a meaningful choice as to the religious practice. The impugned regulation in attempting to secure a social good for the whole of society, the regulation of driver's licenses in a way that minimizes fraud, imposes a cost on those who choose not to have their photos taken. The cost of not being able to drive on the highway. But on the evidence before us, that cost does not rise to the level of depriving the Hutterite claimants of a meaningful choice as to their religious practice or adversely impacting on other charter values. Could anyone suggest that if we don't have our own law school with the right to keep out gays and lesbians, our religious options are no longer available? We have no meaningful choice to practice our religion. To say it is to answer it. Quote, the Hutterite claimants argued that the limit presents them with an invidious choice. The choice between some of its members violating the second commandment on the one hand or accepting the end of their rural communal life on the other hand. But the court went on and pointed to the evidence, said, well, look, we're not destroying your way of life. You've still got that choice. You may have to hire a driver if you want to go on the highways. And that's not too high a price to pay. Obtaining alternative transport would impose an additional economic cost on the colony and would go against her traditional self-sufficiency. But there is no evidence that this would be prohibited. On the record before us, it is impossible to conclude that colony members have been deprived of a meaningful choice to follow or not to follow the edicts of their religion. The court noted, these costs are not trivial, but on the record they do not rise to the level of seriously affecting the claimant's right to pursue their religion. They do not negate the choice that lies at the heart of religion. My point, we are on the fringes in this case of claims that could possibly be made about religion. Now, last time I looked at the Bible, and I don't study it carefully, there was no command, no teaching from anyone. Go out, be fruitful, and found a law school. That is not central to any belief of which I know. Certainly not to the Christian. The Bible does not mention this duty. And quite frankly, fundamentalist Christians successfully attend law schools that are open to all across the country. Nobody closes a door to them. And after graduation, they have nonetheless managed, despite not having their own exclusionary law school, they've managed to live useful and praiseworthy Christian lives. That is a fact. There is simply no evidence of a risk to religious freedom so understood here. There have to be limits on these claims, especially when the harm being caused is so obvious. And it's obvious, I'm proud to say, to the Advocate Society, which is as middle-of-the-road group as you can get, and the Canadian Bar Association, which may have invented the middle of the road. We would look like fools if we acted in the face of what is obvious to all our members. So, welcome to the 21st century. This kind of discrimination is unacceptable. But don't sell religion short. It's not freedom of religion that justifies this bigotry. If anybody justifies this bigotry, you are on your own. Thank you.
Ms. Go?
I've only decided to speak just because I have to call up my notes first.
Just for the reference of other people on the list, Ms. Go will be followed by Ms. Miner, then Ms. Rothstein, and Mr. Lerner. There's more on the list, but just get prepared to make your points.
Thank you.
Thank you, Ms. Go. You've got your notes now?
Yeah, I got it. But I have to admit that I'm speaking with trepidation, as I fear that anything I say will be perceived as having a closed mind. However, if I don't speak, and I do not express the views that I have at this point, I may be accused of not providing TW an opportunity to respond to my concerns. So in the end, I decide to err on the side of speaking as opposed to not speaking. As some of the benchers may know, for many years I was involved in a movement to seek redress for the Chinese head tax and exclusion act. During the late 1800s, tens of thousands of Chinese laborers were brought to Canada to work on the Canadian Pacific Railroad in order to help realize the national dream that the first Canadian Prime Minister, Sir John A. Macdonald, had to connect Canada from coast to coast under one nation. But as soon as the railroad was completed in 1885, the same Prime Minister immediately imposed a head tax on all and only Chinese who wished to come to Canada. Starting at $50, the racist tax was raised to $100 in 1900 and then $500 in 1903. When the head tax was proven ineffective in stopping Chinese from entering Canada, the Canadian government enacted the Chinese Exclusion Act to ban all Chinese immigration in 1923. And the act was not repealed until 1947. 1947 was also the year when Chinese were first allowed to take up Canadian citizenship. It was also the year when a gentleman by the name of Q. Yip was allowed to practice law. The first Chinese Canadian ever to do so in Canada. Mr. Yip was born in British Columbia. After obtaining a degree in engineering, Mr. Yip decided to pursue a new career, law. But when he tried to apply to enter law school in British Columbia, he was turned away. Why? Because the Law Society of British Columbia decided, quite conveniently, that only those who had the right to vote in BC would have the right to enter law school. And since Chinese were denied Canadian citizenship under the British Columbia law, they were also denied the right to vote in that province. Mr. Yip decided to move to Toronto to study law at Osgoode Hall Law School because, thankfully, The Law Society of Upper Canada at that time did not have the same discriminatory rule in place. After graduating from law school, however, it would still take Mr. Yip 5 tries before he could pass the bar exam. On the first 4 tries, he was not allowed to take the exam. He was literally stopped at the gate by the gatekeeper at the Law Society because of his race. On his last try, Mr. Yip showed up in his military uniform and was finally allowed to write the exam and passed. And among the first thing he did as a lawyer was to successfully lobby the government of Canada to repeal the Chinese Exclusion Act. And for his contribution to the legal profession, Mr. Yip was awarded with the Law Society Medal several years before he passed away. The Chinese-Canadian community began the redress movement in 1984 when 2 head taxpayers went to see their local MP and asked, "Now that Canada has a Charter of Rights and Freedoms, when could we expect to get back the money that our government has unjustly taken from us?" Yet it will still take another 22 years, including an unsuccessful class action lawsuit, before the Chinese-Canadian community finally received an apology from the government and the few surviving head taxpayers and the widows were given a symbolic compensation. The class action lawsuit failed in part because the Charter has no retroactive application and the government has no obligation to redress historical wrong under the law. But until quite recently, I have always thought that had the Charter been in place in 1885 or in 1923, the head tax would not have been enacted, Chinese would not have been barred from entering the country. Sorry, I'm getting emotional. And they would not have been disenfranchised and thus excluded from the legal profession. Now I have doubt about my position in view of the discussions we're having today. I'm sure back then, the British Columbia Law Society and the law school, which rejected Mr. Yip, had absolutely no doubt about their legal authority or even their moral authority to exclude Chinese Canadians from the legal profession at that time. In fact, on its face, the rules barring Chinese had nothing to do with race at all. It was simply based on the very technical rule about the right to vote. But as we all know, our rules and our laws were both reflection of the prevailing social values. And sadly, for a very long time, the prevailing social values in Canada were to preserve a white Canada at the expense of our First Peoples and people of color. So today, I hope that our prevailing social values would tell us something different. It would tell us that no one should be prohibited from entering law school or becoming a lawyer because of race, gender, disability, sexual orientation, and so on. So perhaps my question is not so much for TWA. Indeed, I think it's a question for myself and my fellow venturers. What are the values that we should uphold when we decide whether or not to accredit TWU? Would such values include the principles of equality, respect for human rights, and the rule of law? And 20 years from now, if we were to look back at our decision that we're making on April 24th, are we going to say that we have made the right decision because of the values that we're trying to uphold and live up to? Or are we going to say we have made the decision that we're authorized to make based on the rules laid down by somebody else? Thank you.
Ms. Minor?
Excuse me. Thank you, Treasurer. I would like to address the public interest component of our decision and other documents or other requirements that we should look to, like the Charter and Human Rights Code in formulating our views. I express these views now as preliminary views and questions. I agree, excuse me, with the questions and views that have already been expressed by Mr. Anand, Mr. Mercer, and others with respect to this matter. And I'm very interested in my colleagues, other colleagues' comments and any reply that TWU has to make. So I look to them if I have erred in any statement of fact or and in terms of what they may comment on my views. We, and I focus my remarks on the public interest and the admission requirements as they affect those who may ultimately be admitted to the bar in Ontario. And it is the Ontario public interest that we are entitled to look to and must look to. We look to the interest as we understand it, and we also have to look to what charter requirements are and human rights code requirements are. And has been mentioned, the Human Rights Code has a section which directly applies to the Law Society, and that is the requirement to admit persons to self-governing professions, that is ours, without discrimination. And while there is no person before us seeking to be admitted, that principle, in my mind, must inform how we interpret the public interest with respect to accreditation. And if we are going to admit people to the bar without discrimination, I ask how we can do that if we accredit a school which in fact places limits, exclusions, and preferences on groups who in fact happen to be, in this case, protected otherwise by the Human Rights Code and the Charter. So it is not the teaching or the curriculum which has been examined by the Federation, which in my mind is foremost. It is rather the effect of what I understand to be exclusionary and preferential admission requirements. And I'm going to call those people the pool, if I may, and that's with the greatest of respect. So the pool of persons who we may ultimately admit to the bar are those which pass through accredited law schools. At this point in time, the only persons who pass through accredited law schools are persons who have been admitted on non-discriminatory grounds and on the basis of merit. And that is underlying our principle of equal access to education and equal access to the profession. At the same time, we know, I think we can take notice of the fact that there are insufficient places in our law schools to accept all of those persons who are otherwise qualified. There's a cutoff, there's a limitation, but it's not because no one else is qualified. And in fact, we know that persons seek many other avenues and law schools outside of Ontario, and in fact outside of Canada, in order to be admitted to the bar. But the underlying principle, in Ontario at least, is that those people who may come forward to be accredited before the Law Society are those people who have gone through a non-discriminatory process and who have not received any kind of unequal treatment with respect to admissions or, frankly, denial of admission. And my question is, how do we further that principle if we are permitting if we are permitting the pool to be, and this is my language, skewed by a different admission policy which excludes or prefers groups? And I'd like to also add that, and again I invite any comment, but I understand this covenant to exclude more than LGBTQ persons. How could a common law couple satisfy the covenant without having an unfair burden or a different burden on it than a married straight couple? So I understand this to be problematic for common law straight people. Persons might argue that there's a distinction between single and married people with respect to that covenant. I also don't understand, and I invite comment, how a practicing Jew, a practicing Muslim, an atheist could accept and comply with that covenant. So I am very concerned that it is very extensive, and it wouldn't matter if it was only one group, but in fact I think it's more extensive than that. So to my mind, what I ask us to consider, and what I'm very concerned about, is what is the effect of accrediting a school which limits the pool of applicants and extends the pool of applicants two groups on a differential basis and on a basis that's not consistent with the Human Rights Code or the Charter. And going to the public interest principle, again, I'm going back, I'm taking a few steps back to very first principles. In Ontario, we have a commitment, and I submit it's a commitment we should agree with, adopt, and further, and that is equal access to education. Particularly equal access to professional education. And that is one which means that anyone can apply and be accepted on merits. Should have brought some water, excuse me. In any event, thank you. Thank you, Mr. Adams. Of course, we respect the rights of religious institutions or religious groups to have their own schools. And in the elementary and secondary context, we recognize religious schools, but at the same time, we have a fully accessible, open, public access to education. If one chooses to go to a separate school, which we must have according to our Constitution, if one chooses to go to another private school or religious school, so be it, it is open to a person. But there is no burden placed on others with respect to the obtaining of education. At this point in time, we have no private professional schools in Ontario. We have no private universities which grant general degrees. We do have seminaries, of course, who train persons in a religious context for religious service. That's not the issue here. What we have is the application from a general education institution, that is, say, general in the sense of professional. It's not a religious school. And in my mind, that should be very separated from the right to have a seminary or some institution that produces religious officers or ordains, whatever the appropriate expression is, for other religions. So to accept this would be the first time that we in Ontario would legitimize different standards for being admitted to the profession, which would limit, as I say, and I'm concerned about this, that it limit those who are not of that particular faith and who cannot accept the admission requirement. And that, to my mind, as I say, at this point, I'm very concerned that skews the pool, and therefore we would be, in effect, furthering a discriminatory approach towards ultimately admission to our profession. And with respect to the religious right, of course we have to acknowledge that there are religious rights, there are freedom of religion, there's a freedom of association with respect to religion. But the case that Mr. Ruby just mentioned, the Hutterite case, I think is quite helpful. Granted, it was a government standard and it was a Section 1 case ultimately. But what the court advised us to do is look at the nature of the religious right. It's not absolute, and that's been quite evident in the material that we received. I'm not questioning the sincerity or the accuracy of the description of the religious view here. I'm not saying we should go into that. But to pick up a bit on what Mr. Ruby said, what is this religious right? It's not, or what is this religious requirement? There is no requirement to have a law school. There is no requirement to only get education within the context of one's co-believers. It's not a requirement. It may well be a preference, but it's not a requirement. It's not a requirement to wear a particular kind of clothing. It's not a requirement to pray and so many times a day. These are not requirements that have to be observed by the religious in order to satisfy their religion. And the members of this particular religion and persons who sympathize with it are quite able to be full religious participants in their religion without having a law school. They can attend other law schools, and they do. They can be called to the bar through their attendance at other law schools. So I'm very concerned that we start on a path that would, in my view, and my concern would be to change the landscape, to change the pool of those who we will be admitting to the bar in a way that is not just discriminatory, but it's unfair to many others, even if they are not in protected groups. Are we going to have profit-making law schools, and which will give a preference to those people who have means? It's not before us. But the whole principle of open access, of universal access to education, in my view, should be supported here, and it should be supported through avoiding, if at all possible, any kind of admission standard or indirect admission standard which privileges or burdens persons, particularly those who are protected under the Code and the Charter. So those are my concerns. I think they've been echoed by others. And thank you, Treasurer.
Thank you. Ms. Rothstein?
Well, I'm not sure that I have any new insights. I've been so grateful for the comments of all of my colleagues. Like others here, I have labored over these issues, but I have to say it was a joyous labor, not only because a lot of time was spent with Mr. McDowell in the process, but because these issues are really so fundamental to who we are. I welcome the opportunity to educate myself about them. And to that extent, I'm so grateful that this application is before us. But for me, as I said to Mr. McDowell in the end, it really comes down to how you frame the issue. And for me, the question before us is very much the way others have put it, most recently by Ms. Miner. This case is about access to legal education, and by corollary, access to the legal profession. And it is about access in a world in which, as we all know, if we have young children or older children, many more deserving students seek those great privileges than will ever be given the opportunity. That is the context. And with that context in mind, I think it's important to accept that we have a very broad public interest discretion. Open textured, I think the constitutional lawyers in my office would call it. I agree with those who said already that TW 2001 cannot be said to bind our decision-making, let alone our consciences. But I do share the view of many of my colleagues who say, but it is the Supreme Court of Canada, and it is the careful thinking of some of the greatest jurists in the land, many of whom we very much, all of whom we respect. And so I do think it should be given prominence in our thinking. And I've spent a lot of time looking at that case and asking myself the question, what's different? Here's what I've learned. We know from the Supreme Court of Canada decision that the court thought that the BC College of Teachers had a very limited public interest making role, particularly with respect to defining discriminatory practices, defining and interpreting human rights codes, reconciling competing rights. We know that they did not have, that is to say the BCCT, their own bylaw making power as we do. We know that the only relevant bylaw did not oblige them to advance the cause of justice, or generally to take into account the public interest in everything that they do. We know that the BC College of Teachers had not established, as we had in our Rule 504, standards which obliged each and every member of that profession to take on a special responsibility, a very special responsibility to respect the requirements of human rights laws and everything that goes with it. And so, whether or not the BC College of Teachers just had a paper deficit is likely the case. Likely they aspired to all of that, and their decision reflects that they actually saw themselves as having that role. But one can't read TW 2001 without noticing that the court was very concerned that they were actually meddling in somebody else's knitting. It reluctantly or ultimately concluded that it was appropriate for them to consider the discriminatory practices which were embedded in the covenant, but it was, I'm going to argue, a fairly reluctant conclusion by the court. The second thing that I've noted, and others have noted in the submissions that we've received, is that the covenant has indeed changed since 2001. In TW 2001, the Supreme Court of Canada made no reference to there being a mechanism under which the community standards document could discipline and expel a student who did not honor covenant, leading the court to conclude at paragraph 22, and I saw this is so very important, that there was no evidence that anyone had been denied admission or was expelled because of a refusal to sign it. And I pivot on that point because I do not anticipate that in the future that kind of no evidence conclusion would support the court's analysis when the issue put before it was whether or not there were in fact barriers to entry. It was pivotal, therefore, to the court's decision that it looked at, as Mr. Ruby so carefully put it, something very different. It was entirely peripheral, although noted, peripheral to the court's concern that there may be barriers to entry to the teaching profession and that there may be barriers to entry to a teaching education. The court's focus was on whether or not the covenant produced teachers who would foster discrimination in public schools. And I share the court's conclusion that that was very much a freedom of religion and freedom of conscience violation to make such assumptions on the evidence before it. So I say this case is different. I say this case is fundamentally about access to legal education, access to the legal profession, such great privileges that we luckily get to live every day. And I ask myself these questions. Are we really living here at the Law Society in a world where if a private religious university prohibits admission to female students, and I picked that example because I know TW does no such thing and would find it offensive to do any such thing. But I do know that members of my religious heritage have done such things in other jurisdictions. I'm a Jew, and that has happened in some of the Orthodox communities. So I pick that for a purpose. I say to us, would we really say, as governors of this profession, that we are obliged to accredit that religious institution in the name of freedom of religion? I ask myself the question, if a private religious university prohibits interracial marriage, this example has been given, or interracial dating, would we say it's any different because the focus is on behavior and not the identity of any particular individual? Would we say that we are obliged in the public interest to accredit such an institution in the name of freedom of religion? I ask myself the question, if a private religious institution, a private religious university, had a covenant which required First Nations not to engage in sacred practices while they were students at that university, would we say we were obliged in the public interest and in the name of freedom of religion to accredit that university? And I ask us, what is different? What is different if a private religious university prohibits sex and intimacy between an unmarried heterosexual couple, sex and intimacy between same-sex couples, whether married or unmarried? And I say to myself, although my mind is not closed, that is the important question to ask. The harm, in my view, Mr. McDowell, the societal harm is not to be focused on the risk that TW lawyers will discriminate against anyone. I am confident, based on what I've heard from TW, that they will endeavor not to, as we all do. The harm is that this covenant surely has the practical effect, without evidence, without proof, and without testimony, of denying admission to LGBT students, to unmarried students, to a range of people, including from other religions. And it perpetuates very negative, perhaps noxious stereotypes that undermine their dignity and worth, and of course, their equality. And that is my problem. Thank you.
Mr. Werner.
First and foremost, I'd like to welcome our guests from British Columbia and we're pleased that you're here today. Secondly, I'd like to congratulate the treasurer as one who believes in transparency of this organization. I think what we have done today is a statement that ought not to be ignored. At our break, as I looked around the portraits in the other room, I thought I detected a smile on the faces of some of those who have come before us, who fully appreciated the level of the advocacy and the quality of the debate today. And I congratulate my colleagues who have come before me. Like Mr. McKenzie, I think that this is an issue of core values. What I'm concerned about is if we are to accredit at Trinity Western, how am I going to explain to those members of the community whose interests we are required to protect, how am I going to justify the decision that we have made? I've thought about that. I've thought about ways in which it might be done. And to this point in time, I don't have an answer that satisfies me and that I will be able to do so. I find it interesting that if this were a perfect world, we wouldn't need human rights codes. It would be the manner in which we all live without the necessity of having specific legislation to dictate how equity-seeking groups ought to be welcomed into our community. The very fact that we need legislation is indicative of the struggle that has taken place over centuries for the protection of individual rights, whether it be race, religion, civility, or sexual orientation. I am also somewhat troubled by the fact that some have suggested that Trinity Western University is provided with a defense through the protection of the British Columbia Human Rights Code. The fact that they have to defend, to me, suggests that there may be a recognized violation, and that concerns me at a very basic and fundamental level. We are controlled by our mandate to protect the public interest. We are governed by bylaws. Interestingly, at the bottom, our coat of arms, the words, "Let right prevail," appear on all of the documents, formal documents that we issue from the Law Society. I'm not sure that I know what is the public interest, but as someone said before, I think I know what it isn't. I suggest to you that a group that on a monthly basis condemns abuses of human rights around the world may be in the position of having asked our treasurer to write a letter to himself at a subsequent convocation as a result of a decision we might make. I agree with the principle that what happens within the confines of Trinity Western University is its business, and we ought not to dictate the manner in which they control their own affairs. However, I looked hard and long to find some sort of an analogy that might give me some comfort, and I found this. I took the position that if we accepted South Africa unconditionally, the action would be taken as approval, or at least condemnation, of racial policies which are abhorred by Canadians as a whole. I never thought the day would come when I would quote John G. Diefenbaker. But I have. And I think that statement reflects the position adopted by the world community, not just by Canada, but by the world community to the atrocities of apartheid and the restriction imposed upon South African athletes who attempted to participate in the Olympic Games from 1972 through 1978. I believe I prefer to adopt the broad interpretation enunciated in the Pinto opinion, and on that basis, I leave my mind open to be convinced otherwise, but I must say, there are questions that need to be answered, and I look forward to hearing those in due course.
Mr. Sway? Yes, I should say we have Mr. Sway followed by Mr. Faulkner, followed by Ms. McLean, followed by Ms. Symes. And that's the remainder of the list so far. And now we have 2 more, I think. 3 more? Am I bid 4, 5?
On the phone?
Okay, I've got a list. Mr. Sway?
I've had the pleasure of sitting in Convocation for the last 19 years. This probably is one of the most important issues that's ever come before us. We know about the mandate, but let me refer you to a New York Times article. And because the state of Colorado recently had issues, and there's the headline was "Religious Right in Arizona Cheers a Bill Allowing Businesses to Refuse to Serve Gays." And the date of the article is February 21, 2014. In New Mexico, a photographer declined to take pictures of a lesbian couple's commitment ceremony. In Washington State, a florist would not provide flowers for a same-sex marriage. And in Colorado, a baker refused to make a cake for a party celebrating the wedding of 2 men. The business owners cited religious beliefs in declining to provide services celebrating same-sex relationships. And in each case, they were sued. Now, as states around the nation weigh how to balance the rights of same-sex couples with those of conservative religious business owners, Governor Jan Brewer of Arizona must decide whether to sign legislation that would allow business owners to cite religious beliefs as a legal justification for denying service to same-sex couples. We know that the governor would not sign the bill. Why? My submission is because from her perspective, it was wrong. The article goes on to state the legislation approved by lawmakers on Thursday immediately attracted national attention, with conservative religious groups welcoming it as a necessary form of protection for objectors to same-sex marriage, and gay rights groups denounced it as a license for discrimination. The measures comes at a time when the courts are grappling with how to define the religious rights of private businesses. The Supreme Court is to hear 2 cases next month, which businesses are seeking exemptions for providing insurance coverage for contraception to their employees, citing the religious beliefs of the company's owners. To move on in the article, religious freedom is a fundamental right, but it's not a blank check to harm others or impose our faith on our neighbors, said Daniel Mack, who directs a program of freedom of religion, a belief for the American Civil Liberties Union, which opposes the Arizona legislation. Over the years, we as a nation have rejected efforts to invoke religion to justify discrimination in the marketplace, and there's no reason to turn back the clock now. Quote, the article further says, "It sounds like it's opening the door to hate and bigotry of all stripes," said Rocco DiGrazia, a Tucson pizzeria owner, who on Friday attracted national attention via social media because he had posted signs on the restaurant doors declaring, quote, "We reserve the right to refuse service to Arizona legislators." Sarah Warbelow indicated that there's a significant fear that it will undermine local non-discrimination laws. She's the state legislative director for the Human Rights Campaign and Gay Rights Advocacy Organization. This is not about the freedom of individuals to practice their religion. This is about a license to discriminate against individuals. I submit here, it is not right or wrong for TWU to take the position that they choose, but it's rather one of discrimination in general. Today, it's gays. Tomorrow, it's Jews and blacks. The principle is there. I submit, like the Supreme Court of Canada, in a judgment indicated called Noble versus Alley, 1951 SCR, page 64, had to do with a restrictive covenant in a deed drawn in 1933 that provided that the lands herein shall never be sold to any person of the Jewish, Hebrew, Semitic, Negro, or colored race or blood, and the restriction should remain in place until August 1, 1962. A motion was made in the Superior Court of Ontario for an order declaring the covenant invalid, but was dismissed. The decision was affirmed by the Ontario Court of Appeal. In the Supreme Court of Canada, they allowed the appeal. Arguing in that case, it is quite interesting to note that the following names, quite familiar to many of us: J.J. Robinette Casey and Walter Williston for the appellant Noble, J. Shirley Dennison and Norman Lawrence for the appellant Wolf, K.G. Morden, K.C., and J.C. Osborne for the respondents, and the judgment of Kerwin and Tashoe was delivered by Justice Kerwin. I submit to Convocation to search your conscience on this vote. I submit that discrimination in any institution is just plain wrong in this day and age. I've read the opinion of Mr. Meehan, who I respect tremendously. But my question for Mr. Meehan and for the school is the following. To permit the covenant to stand, will that not permit other institutions to take that as a precedent to allow discrimination if we ever have to decide this question in this convocation again? Thank you.
Yeah. I've noted that in making remarks, some benchers have referred to issues or matters that are not actually in the record that is before convocation. And I would just ask benchers to consider, the benchers that are on the waiting list, on the speakers list, if you would keep in mind the advice that we've received, that it's important to limit our consideration of the matter before convocation to the record. And certainly in the debate that will occur on April the 24th, you will not be able to refer to any new material that isn't before convocation on the record. Just keep that in mind when you make
Sir, may I file the...
No.
After 50 years, you don't know that.
So if I could call on the next speaker, please, which is Mr. Faulkner. And I'll just say, Mr. Faulkner, that when you're finished, we're going to break for lunch, so I'm sure you'll be motivated to.
Thank you, Mr. Treasurer, for that. It's not unusual for my colleagues to hunger for my submissions. I want to acknowledge our guests from TWU. I want to acknowledge my esteemed estates professor in the form of Mr. Meehan over there, and friend. I want to acknowledge the excellent advice we received today from Ms. Christensen, and I want to say that in terms of my submissions, I am not only remain open, but I am truly perplexed at suggestions that values are not at loggerheads. I find values today are at loggerheads, and I haven't chosen, and I have resisted creating a hierarchical list of interests. And in doing so, I look forward to hearing from TWU about the concerns expressed today and the questions expressed today. And I look forward to that stage where we make a decision, and I'm certainly nowhere near that. What I also want to say is I benefited from many of the remarks, all of the remarks today. I do want to say I benefited in particular from somebody who was the subject of a point of order, being Mr. Ruby, and his remarks, it's not simply because he's a mentor and a friend, but it's also because his remarks, as usual, as one of the most preeminent human rights lawyers in this country, strike at the heart of what we have to consider. And to any suggestion that we as benchers are incapable of taking positions for our clients and remaining open, this is an exercise we have to do on a regular basis. And for those who would suggest some have fallen on one side, I urge you to look at the board book's record that we're making our decision on, because you will see in there benchers who have been very supportive of TWU in writing who will be making decisions in this process. That is, they are on both sides of the equation. And why? Because we have jobs to do, number one, and number two, we're capable of remaining open and making decisions independently. At the end of the day, I am left with the following, and it's embarrassingly basic. When I hear assertions of the right to congregate, of the right to share expression, of the right to enjoy one's beliefs, these are all matters that I've not just committed to personally, but committed to professionally. And I've always had a line that I've drawn in the sand, and that line generally is around what I call the steamroller effect. To what extent does respecting and upholding a particular set of values in turn lead to the steamrolling of another set of values? I find, as simple as it is, embarrassingly, it's not a quote from the Prime Minister, it's not a quote from the Supreme Court of Canada, it's just how I live my life. If I think I'm steamrolling with somebody else, then I have to ask a very, very serious question. Is this necessary? Is it necessary to make that law student, and I envisage this law student, maybe others don't, but I do, is it necessary to make that law student who's in the middle of their legal education, who may discover themselves in their first or second year of law school at TWU, who may discover something about their own personal identity, is it necessary to make that person feel so vilified that they would have to report themselves to the dean of TWU and advise that they are now in breach of the community covenant? Is it necessary to create a world in which their fellow student, who sees that they are discovering themselves, report them to the dean of TWU because they have witnessed someone who's in violation of their covenant? I don't worry that a TWU grad is going to go out there and be any more prejudiced or discriminatory than half the judges or anybody else I've encountered in my life. You folks will get it as right or as wrong as the rest of us. I worry about steamrolling those who are in no position to protect themselves, and for reasons that confound me. And so I ask this when we talk about the public interest. And I remain open because I want to hear your answers to this. If we are truly to apply the public interest, then don't we have to ask who are members of this public? Is the LGBTI2Q community, right? Are members of that community part of the public? Because if they're part of our public, and they are included in the public interest equation, just, of course, as TWU and others are, then are they not steamrolled? And if the answer is they are steamrolled, then I'm troubled. I remain open to understanding whether they are to be members of the public. I remain open to hearing you on this. There is a quote, and I'm hoping that my annotations can find it. There is a quote that comes from the president of TWU in a letter dated March 21st, 2013, to be found at page 1235 of Board Books, part of our record. President Raymond is writing to the Federation of Law Societies of Canada, and he expresses at page 2 of the letter, quote, top paragraph, quote, the Civil Marriage Act includes a preamble which states, quote, it is not against the public interest to hold and publicly express diverse views on marriage. I agree with President Raymond. My concern is, how does one, and I hope and look forward to the answer to my question, how does one hold diverse views at TWU with that community covered? Or is the answer that you don't hold diverse views if you go to TWU, and we don't concern ourselves with that particular public interest that the President is referring to, but in fact we have a different approach? And if in fact the President is espousing a different approach that is different than this public interest and this fostering of diverse views, how do I reconcile it with my public interest that I have to apply as a venture? I look forward to the ongoing debate today, and I look forward to the answers we receive on April 24th. Thank you.
Thank you, Mr. Faulkner. We'll now rise for lunch and come back at 1:45, so we'll have an hour and 15 minutes for lunch. Thank you.